Okay, good afternoon, everyone, and welcome to the DPO Presents webinar with the Minnesota School Boards Association about data practices for schools. Thank you for joining us this afternoon. So before we hop too far into the content itself, do want to just give you a little bit of a background about the Data Practices Office in case you aren't familiar with us. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government, and we help the commissioner with issuing advisory opinions, and we also provide legislative assistance and training. And I'll maybe turn it over to Terry here quickly because he is our partner too. Terry, if you want to just go ahead and introduce yourself and MSBA.
Thank you, Casey, and thank you everyone for participating today. Yes, my name is Terry Morrow. I'm the Director of Legal Policy Services here at the Minnesota School Boards Association, and we'll talk a little bit later this afternoon about model policies and other resources we have that could be helpful with this content.
Great, thanks, Terry. Okay, so this PowerPoint is posted on our website. So if you aren't able to download a copy today that we'll be sharing in just a few minutes, it is on the page where you registered for the webinar. We do also record our webinars. So if you missed part of today's session or you want to go back and watch it again or find one of our prior series, those are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later on with more information on accessing those resources near the end of the webinar here. So if you'd like to download a copy of today's PowerPoint, I'm going to share the file with you right now to download and save to your computer. Just give me one moment, please. Okay, so you should have a pop-up window that's appearing on your screen. You can select the file and download it to your device. I'll also do this later in the webinar while we're taking questions. If you are having some difficulty downloading it, once again, this is posted on our website on the page where you registered for the webinar. So you can certainly find it there at the bottom of the page. Okay, so moving on here to today's agenda. So today we do have Terry Morrow from the Minnesota School Boards Association joining our office to discuss strategies to comply with laws and requirements governing student and education data and just data practices generally for schools. This is really a great opportunity that we've been looking forward to as an office for a while, because one of the things that we do as an office is we're the experts on the law and the basic requirements. And so we can tell you what the Data Practices Act says and what those mean. But what's really great about having Terry here today is he can really talk to putting those requirements and those rules into practice and really give you some best strategies and some ideas about how to actually comply with the law. Whereas we're more in the position saying this is what the law means, but we don't have that day-to-day experience working with student data or trying to comply with the law in some of the ways that school districts or other educational institutions have to. So this is really a great opportunity to get kind of that 1-2 of the requirements as well as how to actually put that into practice. So we're pretty excited about that. So today's agenda itself, first, we're going to make sure that everybody is on the same page when it comes to general data practices requirements, as well as the state and federal laws that apply to student data. Then we'll turn it over to Terry to cover the steps that MSBA recommends to make sure that you're meeting the requirements of the law of both the state and federal laws, and we'll have some discussion about some of those practices. As usual, we will leave some time for Q&A at the end of our webinar, so feel free to send in your questions as you think of them using the Q&A panel on your screen. When you are sending in those questions, please send them to all panelists so we can be sure to see them. And that just helps us to make sure that we can manage those questions and they're not lost at some point throughout the webinar. Okay, so to start with, we're going to take a few minutes to highlight some key requirements of the Data Practices Act. If you want a deeper dive into the requirements of the law, I recommend reviewing the DPO website or attending our other workshops and webinars. Today's discussion is really high-level information and a quick download to make sure that we're all on the same page when we're talking about data practices and student data. So let's start with the law itself. Chapter 13 of Minnesota statutes is the Minnesota Government Data Practices Act. You'll hear us refer to the law as the Data Practices Act or as Chapter 13. All of that's the same thing. It's all the Minnesota Government Data Practices Act. At a very high level, the law presumes that government data are public, but it also classifies many types of sensitive data as not public. And we'll talk more about that in just a moment. The law grants members of the public and the data subjects with the right to access different types of data, and the law also requires that any data about individuals be accurate, complete, current, and secure. So in other words, government entities must make sure data are correct and establish procedures to protect not public data. Additionally, Minnesota Rules Chapter 1205 are the administrative rules governing the Data Practices Act. The rules apply specifically to data on individuals and provide lots of helpful guidance as you're managing data practices issues. So oftentimes, if you have a data practices questions, one of the best places to look are those rules, because those do give some more in-depth guidance on how to handle certain data practices issues. Digging a bit further, there are two types of government data: data on individuals and data not on individuals. Data on individuals includes data where a living human being can be identified as the subject of the data. Examples include employees' email addresses, students' grades contained in their report cards, or an athlete of the week photo. Meanwhile, data not on individuals are all other government data that are not related to or identify a specific person or people. Some examples might be the makes and models of your district's school buses, the names of companies who are preferred vendors for your district, or a list of district school buildings. In addition to the types of government data, as I mentioned earlier, the Data Practices Act classifies all data into one of three categories of access. The first category is public data, which is available to anyone for any reason. One example of public data would be the names and salaries of all teachers working within a school district. Those data are considered public. The next classification of data are private data on individuals or non-public data not on individuals. These data are available to the data subject, employees within an entity whose work assignment requires access, other entities that are specifically authorized by law to receive the data, and others who are given access to the data through the subject's informed consent. Examples of private data might be employees' home addresses and phone numbers or students' grades. Generally, these data aren't available to the general public, but are available to those people who the data are about. The last classification is confidential data on individuals or protected non-public data not on individuals. This level of access is the most restrictive, and these data are only available to employees within an entity whose work assignment requires access and other entities authorized by law. Importantly, data subjects do not have access to their confidential or protected non-public data. Examples of data in this classification include data collected as part of an active civil legal action. Typically, educational data or data that school districts have don't typically fall into this confidential or protected non-public data, but there may be situations there. Most of the data that I'm guessing that schools are handling on a day-to-day basis fall within that public or that private/non-public data. Just as a general reminder here, the Data Practices Act does have that general presumption that data are public unless the law, Chapter 13, or some other law classifies data in one of the other not public categories. So always keep that in mind. Data are presumed public unless the law classifies it otherwise. So those are the real high-level basics of data, the different types of data, and the various classifications. So I do want to shift gears here briefly to discuss how to manage data and respond to requests. So let's start with some required policies your entity needs to have in place. All entities are required to have two access policies, one for the public and one for data subjects, and these explain how people can submit data requests to your entity. These policies help inform both the public and your entity about how to handle requests and the ways your entity responds. You also need a data inventory and a policy for ensuring security of not public data. The data inventory is exactly what it sounds like. It outlines what data your entity maintains and how those data are classified. For the policy ensuring security of not public data, again, this is pretty straightforward. It's a document explaining the ways your entity makes sure data are protected properly. We do have examples of all these required documents, including model policies, on our website. And you can find the link to those policies right there on this slide. If you do happen to adopt the Commissioner's Model Data Access Policies, we do ask that you let us know. It's just simply sending us an email letting us know that you've adopted those model policies. But again, those policies are available on our Data Practices Office website. Additionally, MSBA and the Minnesota Association of School Administrators have also developed some model policies regarding handling public and private personnel data, as well as for public data requests. And so I think I might just toss it over to Terry here quickly to provide some more information about these model policies.
Well, thanks, Casey. Yes, we do. We have policy 406. That includes the security provisions, Casey, that you just mentioned. This is the public and private personnel data policy. The second policy listed here, policy 722 on public data requests, also includes, Casey, the information about annual notices and postings. And we recently updated this policy, policy 722, which is available on the MSBA website. And I want to thank the Ratwick Law Firm for its guidance as we update these policies.
Yeah, thanks, Terry. And similar on this note, and so we'll kind of move over here to handling data requests themselves. Turning to the data requests, really an initial best practice is to make sure that you have created your data access policies and they are available to everyone, such as being readily available on a website or upon request. And just in our day-to-day work, as a data practices office, when someone reaches out to us and says, hey, I've been having some issues obtaining data from this particular school or this government entity, one of the first things that we often do in the office is go to the website of the entity or to the school's website and look for these model access policies or these data access policies so we know who to get in touch with. The policies should identify your responsible authority, as well as your data practices compliance official, and any other designees who are authorized to receive data requests. And so sometimes it's difficult for us to find these policies, and if it's difficult for us to find them, it might be difficult for the public to also find them. So we'd certainly encourage you that if you haven't created this policy yet, do that right away, or work with MSBA to use one of those model policies, and then make sure that's easily available to the public. That's really the first step in handling data requests, is to make sure that those policies are available for the public.
Casey,
yeah, go ahead, Terry. Yeah.
1 second. I would note that policy 722 has blanks to fill in with that contact information.
Great, thanks, Terry. And that is just a ready-made policy that people can use and kind of use post on your website. And again, one of the questions that we often receive from folks is, who do I send the data request to, or who should I contact if I have questions about data requests? These policies can really help with that sort of work. In addition to the model policies that MSBA has, on our website, we do also have a worksheet that you can walk through and work with that helps you with some different decision points about whether or not you're going to charge for copy costs, or whether you're going to do who's going to be the DPCO, or what are the situations when you may create data. You don't have to create data, but what are situations that you might? And so all of that's on the worksheet that you can find on our website. So just another great resource to take a look at there. So once you've got these policies and they're on your website, they're available for people to have, that's when you're going to really start receiving these data requests. And some keys about these policies here. The Data Practices Act doesn't require a specific process for requests, but we certainly encourage you to have people make the requests in writing. Written requests are going to be easier to track, timestamp, and maintain as a record of what's happened with the request at any given time. Additionally, your policy should document any potential cost for producing copies of data, and you may want to give estimates to a requester up front so there's not any disputes later. These are the types of information that you could provide in that policy and maybe answer some of the questions that data requesters might have before even submitting a request to you. Okay, so when it comes to responding to requests, here's a few tips on what you should do once that data request comes in. First, review the request right away to determine whether it makes sense. If anything is unclear in the request, you can certainly ask the requester for clarification, and you should do so as soon as possible. You'll also want to check whether the requester is the data subject. If the requester is the data subject, the clock starts ticking to respond, and we'll talk a little bit more about that in just the next slide here. Next, you'll want to determine a response. If you don't have any responsive data, let the requester know that the data do not exist and no access to data can be provided. However, if the data exist and are public or there are private data about the requester, then begin compiling the data in order to respond. If the requester is asking for private data about themselves, you'll also want to make sure to have a process ready to verify the requester's identity before disclosing data. Again, that's something that you would document in that data access policy for data subjects. If the data are not public, private data about someone else, or confidential data, then you'll need to inform the requester you are denying access and provide the statutory basis that permits you to withhold that data. There are other requirements related to requests under the Data Practices Act, such as explaining the meaning of data or redacting data when a document has public and not public data. We don't have a lot of time to delve into all of those requirements at the moment, but the key point here is that the Data Practices Act requires your entity to respond in some way to every request you receive. You can't simply ignore requests because, as we've opined, or as the commissioners opined in advisory opinions, no response is a response, and it doesn't comply with the Data Practices Act. Okay, one last thing to mention about data requests is the amount of time you have to respond to a request, which depends on who has made the request. When the data request comes from a member of the public, the response must be appropriate and prompt and within a reasonable amount of time. These terms aren't defined in the law, so a reasonable response can vary depending on the amount of data being requested or the complexity of the request itself. It's a sliding scale, but remember, you can't put off responding indefinitely. You do have to provide a response at some point, but that can vary depending on the request or the complexity or the amount of data that is responsive to that request. When it comes to requests from data subjects, you are obligated to provide access within 10 business days, and there's no exception to that requirement in the law. This 10-day deadline can occasionally be challenging to meet, but our best guidance is to be communicating with the data subject requester to coordinate your response. You can also reach out to our office for some guidance on best ways to comply with this deadline if you do receive a large data request from a data subject. The key to know there is the law requires you to respond with the data within 10 business days.
I just want to jump in here because there's a question in the chat about parents being data subjects for their minor children. And I did want to answer that the Data Practices Act defines data subject to include the parent or guardian for minors.
Great, thanks, Katie. Okay, that was a really quick download of Data Practices Basics, but certainly feel free to throw any additional questions in the Q&A panel. We can answer those near the end of the webinar or as we're going through and having the discussion with Carrie here in a few minutes. You can also reach out to DPO with your questions at any point or to obtain other resources on these issues too. We're always here to help. So next, we're going to turn to some basics about education data before handing it over to Terry to discuss some of these strategies to put all of this into practice. So we'll start really broadly to begin with. There are two different laws to keep in mind that govern how Minnesota's public schools must handle data about students. First, there's the federal law, which I'm sure pretty much everybody has heard of, and that's the Family Educational Rights and Privacy Act, better known as FERPA, along with its related rules and regulations. Meanwhile, the Data Practices Act also governs student educational data in Section 13.32. This section does incorporate much of FERPA into state law while establishing some additional requirements. However, an important point to note here is that if there's ever a conflict between FERPA and the Data Practices Act, the language of FERPA will win out. So that supersedes any of the state law's requirements. Digging in a bit deeper here, Section 13.32 defines educational data as any government data on individuals that are maintained by a public education agency or institution or by a person acting on behalf of those entities, and the data relates to a student. In other words, educational data are going to be most information that school districts and post-secondary institutions maintain about their students. There is one exception, however. desk drawer notes, which are teachers' notes about students that are not shared with others and are destroyed at the end of the school year, are not government data. In short, students and their parents can't access teachers' classroom notes and files about students so long as the data are destroyed when the school year wraps up and they're not shared with anybody else, with the exception of like a substitute teacher. One final note here on this definition is to keep in mind the word maintained. Generally, the Data Practices Act classifies specific items of data rather than documents or data formats. So educational data can be maintained in many different documents and formats, such as in physical papers and files, in electronic gradebooks on a computer, in the body of an email message, etc. We'll discuss these considerations in a bit further depth when it comes to putting requirements into practice, but I just wanted to flag that maintained for you to keep that in mind as we're going forward. Okay, turning to the classification of data. Educational data are classified as private data, but you can find exceptions for when these data may be disclosed or shared in specific circumstances under Section 13.32 of Subdivision 3. Many of the situations where data can be shared involve disclosure for the health and safety of students, and then also the subdivision also incorporates the disclosure provisions of FERPA. As we discussed earlier, private data can also be disclosed with an individual's informed consent, but the rules are slightly different for student data. Only parents can provide consent to disclose their child's educational data, and students cannot typically consent to having their data shared. However, these consent rights transfer to a student upon turning 18. Additionally, FERPA states that parents can still access their child's educational data so long as the child is claimed as a dependent for tax purposes. Normally, the Data Practices Act would limit parents' access to their child's data when the child turns 18, but FERPA overrides those limitations in the educational data context. As explained on the last slide, data about students are private, so they're not generally available to the public, but are available to the data subject. But FERPA and the Data Practices Act do permit schools to make directory information about students available to the public. Generally, directory information would be data about students that would not be considered an invasion of privacy if disclosed. FERPA has a non-exhaustive list of what might be considered directory information, such as names, email addresses, photographs, participation in extracurricular activities, honors and awards received, those types of data. However, prior to any disclosure, schools are obligated to inform parents and students over 18 of the right to opt out of their student data being designated as directory information. Additionally, the school should provide parents and students with a complete list of data that will receive the directory information designation. So that needs to be a finite list. If a parent or a student opts out, then the data about that student remains private. It's not going to be public in those situations. Another issue that we often see come up in the context of educational data is military recruiters asking for information about students. Both state and federal laws require schools to disclose the name, addresses, and home telephone numbers to military recruiters upon request. However, there are some slight discrepancies between state and federal laws on this issue. State law says only high school juniors and seniors data may be shared. Meanwhile, federal law states that all secondary students' data may be shared. The U.S. Department of Education has issued guidance noting that it's the Department of Defense's policy to request information only about juniors and seniors. So there may not ever be an issue here, but I just wanted to flag that and raise the differences in the law for your awareness. And once again, both state and federal law require schools to provide notice to parents or students older than 18 of the right to opt out of a school sharing data with military recruiters. Again, if the parent or student opts out, you can't share the data with the recruiters. Okay, so that was a really quick rundown of the legal requirements. Now I'm going to turn it over to Terry here to discuss the strategies on how to comply with these laws and requirements. But definitely feel free to keep sending in questions through the Q&A panel, and we'll remember to send the questions to all panelists to ensure that we see them.
Well, thank you, Casey. And Casey, I hope you'll stay unmuted because I anticipate we'll have a bit of a conversation on some of this content. So let's go to the next slide here.
Great.
Content. Oh, let me first note, Casey, on the military recruiter requests for data. A couple of years ago, we had questions from a few school districts as to whether districts could charge for the copying the copies of the information. And we worked for a while with the Minnesota Department of Education, and we ended up agreeing that school districts could not charge military recruiters for the copying involved in those data requests. So I just wanted to share that. Casey, let's turn to the form versus the content of the government data. We get a number of questions at MSBA about whether certain types of communications, and we'll turn to that in a moment, dictates whether that information or data is subject to a data request. And it's been my understanding, Casey, that it's the content of the information, not the form of the information, that determines whether it's government data or not. And I include the definition here of government data means all data collected, received, created, maintained, or disseminated, regardless of its physical form, storage, media, or conditions. Before I turn to the next slide, Casey, is this something that you all run against as well? Folks asking about the form of the data?
Yeah, it often is a question that we receive, and this is something that the commissioner has reiterated in advisory opinions quite a bit, is that the Data Practices Act classifies data, not documents. And really, we just use that as kind of a shorthand to keep in mind that data are elements that are contained in different formats, whether it's an email, whether it's a paper file, whether it's in some sort of, other electronic format. Emails aren't classified by the Data Practices Act. It's the content of the email that's going to be classified. And so sometimes an email might just contain a work schedule, or what your plans are in order to teach a particular class. Probably going to be generally public data there. But additionally, you may be coordinating with HR and writing private personnel data about yourself. Both formats are emails, but the content of the latter email, that's going to be private personnel data, and that might need to be redacted or withheld from a data request if it's just a general public requester. So that's a really good point, and an important point to keep in mind is that when we're talking about data, we're not talking about documents or emails or different formats. You really need to look at what the content of those data are in order to determine that classification.
Casey, that's great. And that's what comes up here on this slide. You mentioned email. MSBA receives questions about text messages, voicemail, school district websites, and school district social media. Often the questions that come to us are coming from school board members, but similar questions could come from school staff as well. And the number of questions, Casey, has increased recently as we've seen broader data requests coming to school districts. So for example, data requests that have keyword or phrase searches. We have, for example, one recent school district that received a data request with over 25 keywords or phrases, including the terms equity, diversity, racism, and the like. And the question we were receiving was, what sources do we have to search for these requests? Do we have to search, for example, or school board member text messages to see if they contain any of these terms?
Yeah, another great question. And generally, if the data are being created in the official duties or the official capacities of an employee or a school board member, those data are going to be government data and could be subject to data practices requests. And so that's just a really important point for all government entities, and especially school districts, to keep in mind, is to really be thinking about what is being created, what data are being created, because it doesn't really matter where it resides, where those data reside. If it's in a personal email account, and let's say I'm a school board member, I'm writing up emails from my personal email account, I'm sending that to other school board members or to my constituents, certainly those emails could be subject to a data practices request. That doesn't mean my entire personal email account is going to be subject to, search and retrieval necessarily for a member of the public. But, as a government entity or as a school district, you do need to be able to access all of those data that are going to be government data. And so it doesn't really matter where those data are created or where they exist. if it's related to the work of in your official capacities or the work that you're doing as a government employee or as a school board member, certainly those are going to be government data and may be subject to those data practices requests. And so that's just something to keep in mind when it comes to the various forms and formats that data may exist, is that they do need to be accessible if it is government data.
Well, Casey, you're singing my song that we offer up in our training for school board members. We strongly discourage school board members from using their personal email for school board business for that very reason, that there may be content in those emails that may be subject to a data request. So we strongly encourage school board members, and I would say employees as well, to use school district email and school district communications for conducting school district business, in part because the school district will then be the one retaining and maintaining those communications. And one would not have to go to a board member or a former board member or employee and ask them to whether there's anything in their personal email accounts that would satisfy the data request.
Yeah, and I think that is very good practical guidance, and that's oftentimes guidance that we provide to all different government entities, is to, as a government entity, if you receive a data request, you're obligated to respond. And so making sure that you have access to all government data, because you are responsible for responding. If people are creating data in their personal accounts, you may need to access that. And as district employees, or as just government employees generally, that's also a good thing to keep in mind as employees, is that we probably don't want our employers necessarily going through our personal email accounts to make sure that we've provided all government data in response to a request. And again, that's going to be an internal management issue for all government entities. But I think the guidance that you're providing to districts makes a lot of sense to me.
And then finally, Casey, on this slide, I have to admit, I've been thinking recently about social media and school district websites and the potential that there may be data there responsive to a data request. As part of this consideration, Casey, I've also been looking into ways in which school districts can actually archive and maintain their social media and website communications in case it's relevant to a data request. I know there are a number of companies, and a growing number of companies, that offer these services for archiving social media and digital communication. I'm not asking, we don't offer a recommendation of any particular service, Casey, but I think that's where we're heading, is encouraging districts to at least look into that option.
Yeah, that makes a lot of sense to me. And one of the things that I would also encourage districts to think about on this front is, whether or not these are official records. And maybe I'll turn that back to you, Terry. When it comes to school district social media posts, whether it's Twitter, LinkedIn, Facebook, whatever it is, do you have any thoughts on whether these are official records, or whether it's transitory, just government data? Because the difference there may be a difference in how long these posts need to be saved or documented for records purposes. So do you have any suggestions on that?
Well, absolutely, Casey. I suggest we go to the next slide, and we'll talk a little bit about records retention and official records, because records retention does come into play with the data request subject matter. Every school district, every government entity in Minnesota is to have a records retention schedule. And in our experience here at MSBA, most school districts have used the state records retention schedule available from the Minnesota Historical Society. And then those districts have adapted that state model to fit their own purposes. Casey, this state model for school districts was last updated in January 2000. And I know there are folks, including MSBA, looking at ways to update the records retention schedule. But you raise a very interesting point, Casey, about, for example, retention of emails. And the retention of email period could be relatively short. And then those emails would no longer be maintained. Is that your understanding, Casey?
Yeah, generally, I would say so. And really, the approach. So, the Data Practices Office, we aren't the experts on government records and records retention, as you note on the slide here, Terry. The Historical Society, the state archives are really the experts there. And if folks are interested in the guidance that they have, we actually partnered with them earlier this year to do another webinar about official records and records retention schedules. We did record that webinar and it's available on our data practices YouTube page, so I'd encourage people to take a look at that. But yeah, you're absolutely right. When you have a government record, you're obligated to maintain that according to the records retention schedule. And those official records are really the types of, they're government data, but they're kind of a special category of government data because they really document your entity's official activities. And what some entities might think is an official activity, others might say, that's not one of our official activities. So it really is up to each entity in each district to decide and determine what are its official activities. And so if it is an official record, you need to maintain it according to the records retention schedule. And if it's just other types of transitory government data, then you can delete it at any point. I think maybe a good example using the Data Practices Office is that in our office, our official correspondence, when we are providing guidance or explaining the requirements of the Data Practices Act, that's considered an official record for our office, and we're obligated to retain that for a year before we can delete it. But other emails that we have, where it's maybe me receiving an alert about some MSBA guidance, or me receiving or having a conversation with my coworkers about what a particular provision or word in the statute means, we don't consider that to be an official record. And so I can delete that as soon as I no longer need it. And so that's maybe the difference between an official record versus transitory government data there.
Thank you, Casey. You covered this slide a bit, but I know there are a couple of things that came up in questions that may be applicable here. First, I want to go back, Casey, to your discussion of the responsible authority and making decisions about data requests and how they relate to the work assignment of the individual. And we have experienced here at MSBA that sometimes school board members will go to the responsible authority, often the superintendent, and ask to see certain information that is not non-public. Our recommendation at MSBA for a good practice is first for the responsible authority to determine whether that request would be part of the work assignment of the school board member. Again, I'm focusing on non-public information. But an even better initial step is to have the board as the whole determine whether that information is needed for a school board member to fulfill their obligations as a public official in the school district. We try to turn to the board and have the board consider the matter and determine whether they think that information is needed. But I wanted to mention that because we do receive those questions somewhat regularly about what non-public information can school board members get as elected officials. And we've turned back to the responsible authority and work assignment discussion.
Yeah, I think that's great guidance. And we oftentimes get these questions too, is, who has a reasonable work assignment in order to access not public data, whether it's employees or even school board members. And we do the same thing. We defer to the entity itself. There's nothing clearly in the Data Practices Act that says this is what's considered a reasonable work assignment. This is not a reasonable work assignment. Really it does defer to the entity to make those decisions. And that's just one, just thinking a little more broadly, is there are several things within the Data Practices Act that aren't specifically contemplated. There are times that there is a substantial amount of discretion that is given to an entity, such as how to respond to data practices requests, how to accept those requests. You need to have some sort of policies and procedures in place, but it doesn't dictate how those are. So again, same thing with the work assignment. Someone needs to have a reasonable work assignment to access not public data, but it doesn't dictate exactly what a work assignment might be. So that would be up to each entity as you're ensuring that the protection of not public data and only people who have a work assignment are going through those not public data.
Perfect. Thank you, Casey. Casey, we have a couple questions in the Q&A, but I'm going to just finish out these slides first, but they're questions about directory information that I'm happy to go back to. A new type of data was identified in statute this year. It's part of, it's the new statute 13.463 about educational support services data. And for school districts, we have revised our model policy 524 to cover the new data requirements on service providers of educational technology and the notifications that must go out. For this language right before everybody right now, please look at our policy 515, which is about pupil records and data. So we have included this new definition in our policy 515. I will mention that we have this new notification I just mentioned, and this notification needs to go to parents within 30 days of the start of the school year. This is notification that will be going to parents about the educational technology providers that a school district uses for testing, curriculum, and assessment. If folks like, the Minnesota Association of School Administrators, or MASA, had a webinar and has crowdsourced documents to help school districts with this notification requirement and with other provisions in this law. So I encourage everyone to visit the MASA website. It was a master class on this new law and the notification requirements. In addition, MSBA, we have an annual parent notification chart on our website. It is under resources, then district operations. So we have a list of all the annual notifications that need to go out, and that would include the directory information notification as well. So Casey, I thought I would spend a moment on directory information with you.
Yeah, that would be great. And that's one of the questions that I think we often get too is, what should be considered directory information? And so I would just, pose that to you, what are any sort of strategies or considerations that schools or other educational institutions should keep in mind when determining whether they should decide to, designate data as directory information, or what data specifically should be directory information? So what kind of guidance do you have there for everyone?
So we've covered all of this information, Casey, in our policy 515 that I just mentioned. That's the pupil data policy. Every year, the school district is to provide notification to parents of the types of data that the district is designating as directory information data, and of the right to refuse to let the district use any or all of the types of student information. And this is information we listed in the policy. It includes names, home address, and the like. And then there's also information that parents can choose to have available and not have available. This information we find is sometimes used by companies that are looking, or organizations that have scholarship or other student support opportunities available, and they look to see who's got what honors or awards or might otherwise be eligible. This information also has uses in athletics and extracurricular and co-curricular activities, especially co-curricular activities. Sometimes the media is looking for information about a student. They want to go to the directory information. The key for us when we talk to school districts, Casey, is to have a system that is as clear as it can be as to what information, directory information, has a parent opted out of, and for each student, and then to make sure that, for example, the teachers for that student will know what information about students can or cannot be shared. We run into this sometimes, Casey. It's not about data requests, but just about student privacy and, say, posting photos on a school district website or social media feed.
Yeah, that makes a lot of sense. And in fact, we addressed that, or the commissioner addressed that in an advisory opinion recently. I believe it was 21-008, where there was a school district where there were some issues about managing that consent process and making sure that what the list of directory information was, and then when a parent requested that directory information not be disclosed, making sure that there are processes in place to not disclose that information. And I think the other thing I'd just add with the directory information, especially with that advisory opinion, is that making sure that there's a finite list. If you say, well, directory information might be the name, email address, height and weight of an athlete, etc. That makes it difficult for parents to understand what data might actually be disclosed under that directory information. So you shouldn't really be using that as including but not limited to. Don't be using that language, because it does make it a little bit challenging for data subjects or students and their parents to know whether or not certain data may be disclosed about them, so that they can make reasonable decisions about their privacy.
That's a great point. I'm glad you raised that about the including but not limited to step. Casey, we've been encouraging school boards and school districts to carefully review that list. Not to just not to use the same list every year, but just to think, is this information that is important to go out or to be available to the public and to others, and to keep that list as short as is reasonable, rather than do a long list, because the longer the list, the more potential issues that can arise.
Right.
So districts send out the notice annually to parents. Parents would respond if they are opting out, and that should be made clear in the notification that the parent would need to choose to opt out of one or more of the categories of directory information.
Great. Yes. Yeah. And I think, and one of the other things I'll just mention with the law is that it is an opt-out process, and so you can't require them to opt in. It is an opt-out process, and the law is pretty clear about that. For military recruiter, sharing military recruiter data at the very least. But yes, it is typically an opt-out process, and so if nobody provides any information saying that they want to opt out, and it's presumed that they agree to certain data being designated as directory information. One slide here, Terry, that I don't think we spent as much time on, and I just want to make sure that I can get it here, is handling broad data requests. And you had briefly mentioned this, that there had been some school districts who had received very large requests for all data, and then identifying 20, 25 different terms. I had seen news stories about this at various different school districts. And I just wanted to highlight this slide. We've got a few different suggested practices to help narrow requests to a reasonable range of data, or just handling broad data requests generally. Do you mind giving some suggestions for school districts on what they can do? Or I'm happy to talk through various discussion or suggestions that we provided in the past also.
Well, absolutely, Casey. A few of the things that we'll talk about with superintendents or responsible authorities when they get a data request like this is some do's and some don'ts. We do say that it is perfectly fine to contact the person making the request if there are any questions about what they're really seeking, especially if the request seems overly broad or particularly challenging to fulfill. It may be that the requester really has a narrower or more specific goal in mind, and they can work together to narrow that scope of the request. So that's an early step that can alleviate some potential future problems. One of the don'ts that we include in there is requesters, Casey, if I'm correct, don't have to identify who they are or give you their phone number. Is that correct?
That's correct. Requesters don't have to identify themselves. People can certainly make data requests anonymously. And in that same provision, and so that's, I believe, in 13.05, in that same provision, so they don't need to identify themselves, and they also don't need to provide a justification for why they are requesting data. And so I'll just add on to that, asking a requester, to clarify the request, or asking them to perhaps narrow the scope, or asking, those questions are totally permissible. But the one thing that you can't ask is, well, why do you want all emails about X term? And so you do need to be careful as you're kind of clarifying that scope, that you can't just say, why do you want this data? Because anybody can ask for any public data for any reason at all, and they don't have to identify themselves.
So, Casey, we've seen a number of requests from what would appear to be commercial entities. They want staff name, title, work phone number, work email, and the like. And we remind districts they can't ask, why do you want this? Although it may look like they're trying to put together some kind of sales list. But that leads to this question. All that information for most districts is available on the website.
Yeah, and that's, I'm guessing it's available on the website for most districts. And one of the things to keep in mind here is that when it comes to handling these types of requests, if data are available online, certainly I think it's reasonable that you could point a requester, upon receiving a request, you can tell the requester, hey, this data is easily accessible and easily available on our website, and you can direct them that way. But if the requester comes back to you and says, nope, I would prefer you to provide me with the data, with the request, I certainly think you're obligated to do that. And you can't just simply say, it's available online, go look for it. I don't know that that's necessarily a reasonable response and complies with the Data Practices Act. Because what the law requires is that the government entity provide access to the data upon request. And so if they've asked for a copy of it, then you're obligated to provide a copy. You can't simply direct the requester elsewhere. But it is oftentimes a first step, or a tool that you can use, where you can say all of this data is easily downloadable from our website. And I've seen in my experience handling data requests, 9 out of 10 times the requester goes, oh, I didn't realize that was there. I'll just grab it from the website, or I'll grab it in this way. But if the requester does insist on receiving it from you as required by the law, then certainly go about that. But again, that's just another, I think districts have to be careful, or all government entities have to be careful, because the obligation is to provide access, not direct someone to a website. But that is maybe one tool that you can potentially use as you're thinking about data requests.
And Casey, we talked some about the large data requests, a request that could return thousands or tens of thousands of documents in response to the request, and talking to the requester about the challenges and the timeline and the like. But Casey, we get a lot of questions about what about recouping the cost, the actual cost of putting together a response to the data request. I was wondering if you have guidance or thoughts on that.
Yeah, that is a great great question. And when it comes to providing copies of electronic data, most oftentimes with these requests, you're going to be searching through emails. You can charge the time it takes for the employee time to search and retrieve data. And then there's other costs, such as the cost to prepare materials, the cost to send the request, any sort of costs that are associated with duplicating data, or creating copies that your entity isn't able to do. That doesn't often apply when it comes to these large requests, when it's for emails or for terms. So really what you're looking at is employee time for search and retrieval. And with that, you can only charge the employee's time, the lowest paid employee who can reasonably do the task and can find the data. You can include the fringe benefits and various costs related to that. So it's not just simply salary. It could be the entire cost that the entity would pay the employee. But that's what you can charge when it comes to these requests. The Data Practices Act, isn't really designed as a tool to make money or to be profitable by any means, of course. And really, these copy costs are designed to recoup some of the costs. Obviously you're not going to cover all of them, but I would always encourage any sort of government entity, if it's a request for inspection or a request for copies, to always be documenting those costs, especially that employee time for search and retrieval, just so you can say, these are the number of hours that it took. This is the rate that we're charging in order to assess those costs. But yeah, I know that is a concern that we hear from a lot of government entities, but there are just limitations, and that's a policy choice that the legislature has made, is that you're not going to be able to recover all of the costs, but really, making sure that you're closely tracking which employees can do this work and who's actually doing this work, and documenting their time in order to assess or recover those costs as needed. But the other thing to keep in mind is that you're not obligated to charge copy costs with large requests. Certainly people want to, but if it's a smaller request, you're not obligated to. At our office, we don't charge requesters copy costs until the fee is over $50. And so we oftentimes provide most of the data for free from our perspective. But that's a good question there too. And as we're here, we are kind of getting near the end of the time. And so I do want to just leave some space for any additional questions that are there. Additionally, I am going to open a poll for everyone just to let us know how we did today, and certainly let us know how, if there's any other organizations that you'd like our office to partner with. Additionally, we do have a variety of ways to get in touch with us and contact us. And that's all on this final slide here too. But yeah, I'm certainly happy to open it up to any additional questions here that people have.
Casey, there's one that came up here about whether the public has to identify themselves or give their name, address, and the like when they speak at an open meeting at the school board. MSBA's recommendation is that school districts should not require people to provide their address. It is helpful if they provide their name, but not their address. There's not a law that says who can and who cannot speak in a public comment period. That is the school district's local authority to make the decision. And we've been recommending that districts focus on whether the speakers have a direct connection of some type. They're a parent, student, staff member, taxpayer, or the like, some direct connection with the school district. And they just say, by speaking at our meeting tonight, you are indicating to us that you come within one or more of these categories. So we do not recommend getting the address of people who speak at open meetings.
Yeah, and from an open meeting law perspective, there is no right under the open meeting law for to speak, for the public to speak at a meeting, and so there is no requirement that there needs to be a public comment. There is a requirement if it's a virtual meeting or an interactive technology meeting, if that's the past practice or the general practice of the public body. But there is no affirmative obligation to allow a public comment period. But if you do, then certainly following MSBA's guidance on that, on what to collect and whether to collect information, that would certainly defer to that guidance and whether the district wants to do that. One other thing, just as I'm thinking about whether people can submit data requests anonymously, that I just want to add here is that people can certainly submit data requests anonymously unless it's for private data about themselves. Obviously, if someone is asking for private data about someone and they say they're the data subject, you do need to confirm that person's identity. So that is the one situation where people can't ask for data anonymously. So I just wanted to add that as a clarification.
Casey, we have another question about whether it's acceptable for school districts to remove a student's email address from directory information lists.
Again, I would say it's really up to the schools themselves to determine what those directory information is, and I guess, yeah, Terry, there's no requirement that emails be directory information. And in fact, I think recently the state legislature was considering legislation that would say these sorts of personal contact information can't be considered directory information. That didn't pass, but it was something that I believe the legislature was discussing and thinking about. But Terry, what are your suggestions about whether or not that email should be included as directory information?
I believe the school board and the school district have the authority to make that decision. Just as you said, I would not be inclined to put contact information for a student, for a minor on the directory information list.
All right, and we are nearing the end of the webinar here, and so I just want to make sure that we don't have any other questions, and maybe I'll just hear from my colleagues if there's any other questions that we missed, anything that we have not addressed.
We had a couple other questions about copies of the presentation and recordings. We are recording this webinar and it will be posted on your YouTube page. And the copy of the PowerPoint is on our website, on our webinars page, where you found the link to register for this webinar today.
Okay, and I am sharing the PowerPoint presentation one more time for everybody to download. There should be a file transfer screen that popped up, and so you can certainly download that if you would like. But if we didn't get to your question today, we can certainly follow up with you and answer those. Or you can always feel free to reach out to us with our contact information on the slide here. And if you did have questions specifically for Terry, certainly feel free to email us. We know how to get in touch with Terry also, and we can forward your questions on to Terry if you have one specifically for him too. So Terry, any other final thoughts or anything else that you want to briefly address here before we wrap up?
No, Casey, I just want to thank you and everyone at Data Practices. This is a very helpful opportunity for school districts, school staff, and school board members. And I know we're all very grateful for you sharing your time and your guidance for us as we head toward another school year.
Great, thanks, Terry. And thanks again, everyone, for attending. We do hold webinars about every month, once a month. Some months we do take off, but those are free, and we do have a variety of workshops and other trainings that are available for everyone, and you can find those on our website. So thanks again for joining us today, and we appreciate it, and good luck with the upcoming school year. We hope it's a good one for all of you. Thanks.